My name's David Sturkey. I'm the zoning hearing examiner for the city of Cincinnati. I'll be presiding over the hearing today. I'm going to go ahead and get everyone checked in now. So as I call your name, if you could just confirm the name on the screen is correct and let me know who you're representing here today, whether you're the applicant, property owner, neighboring property owner, someone else from the community, or someone else. So I'll start with Jeff Osterman. If you could unmute, Mr. Osterman.
And I'm the architect, and yes, I can hear properly.
Okay, great. Thank you. Go to Jody Ashendorf.
I'm a neighbor.
Okay, welcome. Scott Phillips.
Yes, Scott Phillips, Frost Brown Todd, 9277 Center Point Drive, Westchester, 45069. I represent the applicant, Chris and Angela Hable.
Okay. And Chris Hable.
Good morning, Chris Hable. I am the resident at 22 Rennel Drive, along with my wife and the applicant here.
Okay. So Angela and Chris Hable are both the owners here. Okay, yeah. Great. Are we waiting on anyone else from the applicant owner side before we get started today?
No.
Okay. I'm going to read through our hearing script. This will just cover the procedure for the hearing and then we'll get started. So this is the September 25th, 2024 session of the zoning hearing examiner docket. The case before us today is case number ZH20240115. That's 22 Rennel Drive. The purpose of this hearing is to allow applicants and any other parties to testify and to offer and refute evidence and testimony. This hearing will follow rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any other party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. So for our purposes here today, I'll allow Mr. Phillips and Mr. Osterman and the Hables. Really, however you want to orient your presentation is up to you. I'm pretty liberal about how you want to do that. Mr. Phillips, if you want to do it with a more traditional sort of opening statement and then direct examination, you can do that. Or if you'd just like to turn it over to your clients to talk about the project, or to Mr. Osterman to talk about the project, that's perfectly fine as well. After you've done that, I'll allow anyone from the public to speak about the project if they would like. I'll then hear from the planning department. I failed to acknowledge Trey Sheldon, who's here from the planning department, but he's prepared a staff report in connection to this case, and I'll allow him to provide any testimony in addition to that staff report if you would like. Let's see. In the event that any party testifies or offers argument in opposition to this application, the applicant will have an opportunity to respond to that testimony that was offered in opposition, and then finally, the applicant will have an opportunity to make any closing statements. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. In the event of any technical difficulties with the Zoom technology, I'll do my best to troubleshoot those issues on the fly, but to the extent there's some defect that prevents us from meaningfully going forward with this hearing, I may continue or postpone the hearing at my discretion. Okay, the last thing I need to do here is just swear in all of our witnesses. So if you intend on providing any testimony here today, making any comments, asking any questions, really doing anything other than just strictly observing here today, and you are not an attorney, then the zoning code requires that I swear you in. So if that's you, if you could take yourself off of mute now, raise your right hand. I'll need everyone to answer out loud. Do you swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Yeah.
I do.
Okay, great. Thanks, everyone. Mr. Phillips, are you going to be taking the lead here?
Yeah, the way we wanted to do this is I'll just give some very brief couple-minute overview, focusing primarily on the legal issues, and then I'm going to turn it over to Chris Hable to give you a little bit of background. We don't expect Jeff to need to testify, but he's available if you have any questions for him.
Okay, sounds good. Floor is yours.
So we have really two arguments. The first is an appeal of the planning examiner's decision, indicating that this house should be oriented for the first time in over 100 years to the west instead of the north. And I certainly understand how the hearing examiner got to that point. However, when you look at all the evidence that's been submitted, and I just wanted to confirm for the record that you do have, a packet of information that was sent by Mr. Habel with the notice that we would submit as basically the factual record of what's happened in the historic. The fact of the matter is the house has always been oriented towards Linwood, and the determination of moving the in essence the front of the house 90 degrees may make some sense with respect to the interpretation of a panhandle lot. However, we believe that the Habels have a vested right to have the house oriented towards Linwood, which is where it always has been and was prior to the zoning code, this particular provision of the zoning code even going into effect. So that's our first argument. Our second argument is in the alternative. We believe that if you make a determination that the hearing examiner was correct, then we are requesting a variance to allow a relatively small addition to this house to be put on, and would indicate that staff has indicated their support of such a variance, as well as the community council submitted a letter in support as well. So that's our alternative. In one sense, I think it would be tempting to just go with the variance request. We're going to ask you to seriously consider not doing that, or, well, giving us a variance if you don't overturn the plan examiner's decision. And the reason for that is basically if the house is reoriented 90 degrees and now fronts off of Rennel Drive instead of Linwood, where it has always fronted off of, the entire house is now non-conforming. And while that isn't really that big of a deal for the Habels with respect to what they're doing right now, assuming that the variance is granted, it is a big deal with respect to their ability to sell it in the future, because it's my experience, having done this over 30 years, lenders sometimes get really nervous about lending on non-conforming lots. And this reorientation, if the house is oriented towards Linwood, it's in conformity with all setbacks. If it's turned 90 degrees, it's out of conformance with all setbacks. So from a long-term property value consideration, we strongly believe that the house has been and should continue to be oriented towards Linwood. With that, unless you have any questions, I'll turn it over to Chris.
Yeah, if I could real quick, just to make sure I have it clear. So your argument is that the actual frontage for the property is Linwood Avenue?
Correct. And that's where it's always that's where it's always been, and that's what all the evidence that we submitted in our packet indicates, that it's always been oriented that way.
And is that just because it's the functional front of the house, or that it's closer to Linwood? What is the argument that is the front?
So Chris can get into excruciating detail on this, because he apparently had nothing better to do over the last couple of weeks than to do all this research into title research. But the fact of the matter is, when the house was originally built, it was on that lot by itself, and Rennel Drive was actually a driveway. It wasn't a private street. It was the driveway to that house. As the house got subdivided, the lot became subdivided, then Rennel at some point in time became a private street. But historically, the Habels have always had access off of Linwood directly, had they chosen to utilize that through ingress and egress easements. They're still in existence, along with utility easements. So the fact of the matter is that when they established the house, not only did the owner, the builder, consider Linwood to be the front, but so did the city when it gave approval for the subdivision plats that ultimately went into effect, with, again, Rennel being a driveway, not a private street at the time.
Got it. And so you said there is vehicular and pedestrian access from the property to Linwood?
There is
Currently?
he has two easements, well, at least two easements. He has a direct easement that runs from his lot directly to Linwood, which would be kind of on the east side, like directly in front of, which is a utility easement, which is where the utilities come from. And then he also has an easement that runs from his property over Rennel Drive. So Rennel Drive, he has an easement that goes directly to Linwood.
Okay. All right.
I mean, the consideration of the panhandle is not Rennel Drive. It's that there's just a small little piece that goes from to the west that connects his lot through another easement to Rennel. But he has continued access off of that. And again, on top of that, to demonstrate kind of how this has always been situated, the house is oriented towards Linwood. I mean, the front of the house is facing Linwood. And I understand that that's not dispositive, but I think it certainly goes to the evidence supporting the vested right that they have for the house to remain oriented towards Linwood.
Okay. Last question. If the zoning plans examiner did interpret the frontage to be on the Linwood side, would any variance be necessary for the
No.
proposed addition?
No.
So it would be permitted by right. It would be within the
Correct.
allowed setbacks.
Yes, he would be within the current setback.
Okay. All right. I think that's all the questions I have right now. So you want to?
Chris?
So thank you for the questions. And again, I appreciate for Mr. Sheldon, this is not cut and dry. It is and I'm a lawyer and a civil engineer with surveying background. So this is not a piece of cake situation, but on this 90-degree issue, things are already kind of confusing enough up there. This just throws more confusion to the situation. So if you look at the document we filed, page 2, there's a figure there. And on that, it will help explain the questions you were just asking. So on page 2, the figure, I don't know if you have it, the yellow I can put up on the screen. The yellow of that was the original parcel that the person who built the house in 1920 owned. So he owned all of that ground. There was no subdivision, and the house is the red, and the driveway was basically the blue and the green coming up to the house, and his utilities, my water and sewer, connect to Linwood through the other blue line to the east. So from day one, the house fronted on Linwood, and it had a driveway. When these lots were subdivided out, and that's what's the rest of what we submitted, there was permanent easement retained benefiting our parcel for both ingress and egress. That's the blue line to the left or the west, as well as the utility easements. They go through multiple parcels. They're reserved in multiple deeds. So I understand the panhandle issue. When you look at our parcel, you say, well, the panhandle is to Rennel Drive. Well, the panhandle actually, in our opinion, my opinion is the panhandle is actually to Linwood. So if this is a question of, well, the panhandle zoning requirement says it's got to be fronting the front of the panhandle, I would argue the panhandle actually connects to Linwood because I have legal right that I can go through all of my neighbor's property to get directly to Linwood, not one place, but actually two. So that is the basis for the 90. And this turning at 90 degrees, another issue that kind of is created by this, candidly, is, with the recent changes to zoning, this, not that I have any plan to do this, but this house could be knocked down and a 4-family could be built there. And we actually share driveway access with the house next to us up that panhandle. And within the setbacks, I could basically cut my neighbor off access to their property because that panhandle doesn't come at the corner of my lot. It comes in at the middle. So this turning at 90 sort of, you couldn't do that if it's oriented towards Linwood, but you can do it if you say and again, we do not want that scenario, but it just, this turning at 90, again, I get where the logic was on it. It just creates a bunch of issues. If you're going to turn at 90, we would argue the panhandle connects to Linwood. And again, if you put the front at Linwood, this is well within, I'm several feet within the side yard setback. There's no need for a variance. So, again, we prefer to kind of not have any more cloud on this. I can tell you the deeds and the lots and all of this up here are not the model of clarity. So adding a little more confusion is just, in my opinion, would be best to be avoided. So that's all I have. I'm happy to answer any other questions you may have.
Okay. I don't think I have any other questions right now. That was clear. All right. Anyone else on the applicant owner side want to provide any testimony
No,
before we
sir.
move forward? Okay.
Do not
All
need
right.
to.
Okay. So Ms. Ashendorf, now is the time for any public comment if you'd like to add anything here.
No comment.
Great, thanks. Okay, we'll turn it over to Mr. Sheldon. Trey?
Good morning, everybody. Yeah, this is simply a circumstance. I ran this by through our staff meeting and to the zoning administrator, and also spoke with Mr. Sturkey as to this determination. When we have unusual panhandle lots, also corner lots, Mr. Phillips is probably well aware of the unusual circumstance that happens sometimes with panhandles and with corner lots. With corner lots, for example, the zoning code requires that you do the frontage based upon the shorter of the two sides. If it's within, if it's not within 10% of each other, for example. So you do sometimes have variances for, typically we have them for accessory structures, like somebody putting an accessory garage or detached garage or a pool or something else, where the front of the house may to them be oriented on the side street, whereas for zoning, it ends up on the shortest of the sides. So this typically happens, and it's exactly the reason why you have this process for variances, because otherwise you have functional absurdities, which I believe this to be. But that's the reality of how we would interpret frontage. There are many places in Mount Lookout and Hyde Park with older homes when the subdivisions occurred, where there are private streets. And if we didn't use the private street as the frontage, we would have not only a zoning kind of a mess as far as zoning interpretation, but also there would be quite a mess as far as the legality of a lot of the access and egress. You have streets like Weebatook and Baker Place and all kinds of places around Hyde Park and Mount Lookout that have this kind of situation here where you have a private street created and a whole bunch of cross easements across other people's properties. So I've not had a situation where I've recommended denial in a situation like this. It's very unique. I think the Hables did a fantastic job of presenting their the factual matters on this. And obviously, at some point, that house did front on Linwood. It was a larger, I think, 8-acre parcel 100 years ago. And then it was subdivided, and now the egress for zoning, simply the access and in fact the easement is to the west and not to the north, even though they get their utilities. They have an easement for utilities apparently across two different properties up to Linwood. So I'll give an example. The house immediately to the south, David, it was built in 1956 and has, I think Mr. Hable misreferenced it because they also have a panhandle that kind of goes parallel to the, kind of roughly parallel to the Hable's panhandle. That house was built oriented to the west, so the panhandle is in the front, so they don't have that same unique situation that you have here. I was in full support of this variance, and have indicated that to Mr. Osserman. And we also run into these sometimes in our hillside overlay situations where you have a maximum building envelope that renders a lot virtually unbuildable. And it's those kind of skewed situations that are the very reason for having the variances and make it very easy for us to recommend approval. I do completely agree that if the frontage were the same as the orientation of the front door, that this would be compliant. And I've done a pretty detailed job in my staff report of explaining. I think there's absolutely no adverse impacts on any adjacent properties. This is a very modest proposal to expand and remodel their kitchen. It won't be seen by the properties to the east. There's very full vegetation there, and topographic difference of some almost 20 feet, I believe, down to the properties to the east. So, David, I don't think any of those properties will really even see this addition. It's only a one-story addition. So, as to any adverse effects, I find absolutely no adverse effects on any neighbors, and wholeheartedly recommend approval for that relief.
Okay, thanks, Trey. Turn it back over to Mr. Phillips. If you or your clients would like to respond to anything that Trey said, or make any statements in closing or otherwise before we adjourn here today.
Yeah, very, very briefly. So I heard Trey indicate that he acknowledges that at one point in time, the house was oriented towards the north. And I think that is dispositive on the argument that we're raising, namely that at some point in time, the Habels established the frontage towards the north. When the zoning code was changed to add this panhandle provision to it, that it did in fact change from a zoning perspective. However, they established their non-conforming use. So they have a legal non-conforming use to have the house oriented towards Linwood. If they abandoned the use and it went away, then yes, the new owners would have to come in and in essence orient it towards Rennel. But given the fact that it doesn't seem in dispute factually that this house originally, was oriented towards Linwood, the vesting occurred that way, and the interpretation that has been made here, in essence, will take away a property interest, namely their right to not have their lot become completely non-conforming from a setback perspective, as well as potentially other things too. So really appreciate Trey's recommendation on the variance. We certainly appreciate his willingness to work with us, and I completely understand his position and don't necessarily disagree with it. However, I think the one piece that is missing that has now been established is, from a factual standpoint as well as a legal standpoint, they have a non-conforming use to have their house oriented towards Linwood. Okay.
Thank you. I think unless anyone else wanted to say anything, I think we'll leave it at that. I want to thank everyone for their very thorough and professional presentations here today. I'm going to take a look at all the materials that I have and look over the testimony here today a little bit more before making a formal decision on this. I mentioned at the beginning, it typically takes about 2 weeks. I think that's a realistic estimate at this point, just based on the queue that I have. As soon as I make a decision on that, I will put it in writing. And typically what I do is just put it in a PDF and then email the formal decision out to everyone who's in the hearing here today as soon as it's complete. And then once you have that, Mr. Phillips, and to the Habels, you all can take the next steps. I think it's safe to say that whether I agree with the arguments about the frontage, or if we're just looking at the variance, that I am going to approve it and the addition will be able to be built. So there will be approval one way or the other on this. But I'd just like to spend a little bit more time after hearing some of these arguments to make a decision. So if you have any questions in the meantime, feel free to reach out to me. Or if you just like a status update on the decision, I'm happy to provide that to you. But I think 2 weeks is probably what we're looking at here.
Fantastic.
All right.
Thank you, David.
Any other questions?
I just want to point out that since this is already in for building permit, Mr. Osterman, as soon as the decision is issued one way or another, either way, as David has just stated, we'll be able to go forward with this project. So I'm going to be in town throughout October, and so as soon as a formal decision is issued, I'll be able to immediately approve that permit, which I believe has been already approved by the building plan examiner. So,
Yes, it has.
yeah, so you should be, as soon as David issues that decision, I will promptly approve that building permit. You'll be ready to get started.
Thank you very much, Trey. I think that will preserve marital harmony to get that approved and built.
Yes.
Good luck with the addition. It's a beautiful home. By the way, I didn't get to put that in there, but it's really a gorgeous home.
Thank you. It is.
Thanks again, everyone.
Thank you.
Hope you all have a wonderful